Ignorance of the law is no excuse in any country. If it were, the laws would lose their effect because it can always be pretended. Thomas Jefferson. In your opinion, is not knowing the law an excuse to break it? Why or why not? Take a moment now to respond to that question. In Chapter 2, we are going to look at defenses that can be used in a courtroom when faced with criminal charges. In our criminal justice system, persons accused of a crime are innocent until proven guilty beyond a reasonable doubt. This burden of proof is laid upon the prosecution. In our system, defendants do not have to prove they are innocent, while in some other countries they do. During a trial, the criminal defendant and the defense attorney do everything they can to prevent the prosecutor from proving guilt. Most defenses consist of raising reasonable doubt about the prosecution's case. A defense attorney will cross-examine a prosecution witness and bring out inconsistencies or contradictions in their story, raise doubts about a witness's believability, or show that their identification of the defendant is not reliable. This is known as impeaching the witness. The prosecution must establish to a jury or the judge every element of the crime beyond a reasonable doubt. If the defense can prevent the prosecution from doing this, then the defense has to win. Now, just to clarify, there is a difference between being found innocent and not guilty. But in a courtroom, it's only ever guilty or not guilty. There is no third option. Innocence means that you did not commit the crime, whereas not guilty just means that there's insufficient evidence to determine that you did commit the crime. Affirmative defense. If the defendant successfully establishes one of these affirmative defenses that we were going to review, it does not matter whether or not the prosecution can prove all of the elements of the crime or not. The first type of affirmative defense is known as justification. This means that the act was not wrong, it was justified under certain circumstances. Next, we have the excuse defense, which, although the act was wrong, the defendant had a good reason. There are 6 different types that we'll get into in just a moment. Lastly, we have the Statute of Limitations, which prohibits prosecution of a criminal if legal action starts too long after the commission of a crime. The first type of justification defense is self-defense, where you have the right to defend yourself. So if Bob attacks Jose, Jose has the right to defend himself. On page 40 of your textbook, there is an article that goes into this a little deeper. I would like to point out that the state of New Jersey requires that the person has to retreat first. If it's not possible that they can retreat, then the 3 following elements must be provided in order to constitute self-defense. Number 1, the force used must be immediately necessary. 2, the force against the person or perpetrator must be unlawful, and the amount of force used must be necessary. So, in other words, in New Jersey, the victim must be threatened with immediate illegal violence or other unlawful action, and that action required the amount of force in which the victim responded. A defense of self-defense in the courtroom is disregarded if these conditions are not met. For example, if someone is threatening to assault you, you have the right to fight back. However, if the threat involves the use of fists and you pull out a knife, then that's not going to work in New Jersey. The use of the knife is considered excessive force and not covered under self-defense. And deadly force is only justifiable in New Jersey if the victim reasonably believes that that's what they needed to do in order to protect themselves because they believed that they were going to die or get seriously injured. Next type of justification defense is necessity. This is where you admit to committing the illegal act that's normally criminal, but it's justified under certain circumstances. There are 3 elements to necessity. You didn't intentionally cause the circumstance surrounding the illegal act. You couldn't accomplish the same objective legally, and you chose a lesser evil of your options. So, for instance, there's a pregnant woman in your car, and she's gone into labor. So you need to speed down the freeway to get to the hospital. We know that speeding is illegal, and you can get a hefty fine along with your ticket. But if you claim necessity, in this particular instance, you might just win that case and get that fine dropped. There are 6 types of excuse defenses. The first is duress, meaning that you wouldn't have committed these acts of criminal, you would not have committed these criminal acts unless someone pressured you to do them. But pressuring in the form of threats, violence, constraints, or other action. So if you're looking at the textbook, it covers 3 different requirements of duress. 1, the person was under immediate threat of serious bodily harm or death. They had a well-grounded belief that the threat would be carried out is second. And thirdly, they had no reasonable chance to escape. Next, we have insanity, where a medical condition could affect someone's judgment and they're consciously unaware of their actions. So perhaps a schizophrenic just went off of their medication and now they've gone on a criminal rampage. They wouldn't have done it if they were on their meds. So an insanity defense might just be what they need in the courtroom. We'll look more at insanity in a later lesson, though. Next, we have entrapment, which is committed because the police tricked you into it. On page 45, there's an article regarding entrapment, but it's a little complicated, so we'll also look at that one in a later lesson. Now, just to clarify, there are specific types of charges that you can use a duress defense against. For instance, arson, kidnapping, robbery, burglary, and on occasion, but not always, felony murder, if it negates the underlying felony. So, for instance, Bob has a gun to his head, and Joe tells him, take this and light this building aflame. That would be arson, but they don't know that Karen's inside. So that would be felony murder when she passes from the arson, in which case this might be an acceptable use of the duress defense. Now, just to clarify, duress and necessity as well cannot be used for first or second degree murder. Duress can only be used for felony murder if the person was forced into committing an unrelated felony and did not intend to kill the person. This again goes back to our lesson on intent. We still have 3 more excuse defenses left. This one goes back to the do now that we did in the beginning of this video. Ignorance of the law. A person who is unaware of a law might not escape liability for violating that law. Common law states ignorance of the law is no excuse, or in Latin, ignorantia legis non excusat. This rule still applies to most crimes. So, what about that bank robber? He said he didn't know it's illegal to rob a bank? But that doesn't matter, because he still committed the crime. Society demands that people understand what is against the law. After all, isn't that the rule? Next, we have mistake of fact. While a person has committed the physical element of an offense, there's a serious lack of intent here. So if Jay and his girlfriend are at a party and she says to him, "Dear, please go get my purse," but he grabs Maria's by mistake because it's identical, and obviously here there's no intent. Therefore, the elements of the crime are not present, and he can use mistake of fact to defend himself when Maria brings him to court for theft. Lastly, we have intoxication. Intoxication is kind of tricky because it depends on whether or not you choose to be intoxicated. In other words, were you roofied? Or did you have that drink on purpose? A person may get intoxicated from drugs or alcohol and do something that they probably wouldn't do sober. It's still no excuse for the crime, except if the person unknowingly ingests the alcohol. This is known as involuntary intoxication. Let's take a little deeper of a look. In more legal terms, intoxication can be used if it negates a required element of the crime, whether voluntary or involuntary. In other words, what's the level of intent here? Voluntary intoxication cannot be used for a rape charge, but it can be used for other criminal charges. However, you still have to prove that they legit thought they had consent and did not meet the requirement of criminal intent. Lastly, let's look at statute of limitations. Legal action must be brought within a period that begins from the date of the criminal act, or the defendants can raise this defense and bar or prohibit the criminal proceedings against them. As we mentioned before, it prohibits legal action to start too late after the commission of the crime. Passage of time may obscure evidence and turn eyewitness accounts into distant, faded memories. Most misdemeanors have a statutory period of 2 to 3 years. Most serious felonies, like rape or robbery, have longer statutory times of 6 to 10 years. Some jurisdictions do not have any statute of limitations for more serious felonies. However, there is no limitation on a murder charge anywhere in the U.S. The purpose for these limitations is to help to preserve fairness, as it's considered unfair to charge the defendant with a crime based on old and stale evidence. Let's face it, can you even remember what you had for breakfast yesterday? What about a month ago? What color shirt did you wear on the day of your 10th birthday? Unless you have a picture, you probably can't answer that question. A couple of things can stop the clock on the statute of limitations from running out. For instance, if in one state the defendant flees the jurisdiction, the statute does not run while the defendant is in hiding in a different state. Additionally, if a charge is brought against the person legally, but then they flee, that's another instance where the paperwork's already been filed, even though they're not around. So the statute can still be stopped. Another important factor is DNA. DNA evidence has impacted the statute of limitations defense because DNA does not fade over time, whereas eyewitness accounts do. It is viewed as reliable even many years after the crime. Laws regarding DNA evidence are still in their infancy. Title 18, Section 3297 of the U.S. Code states, a defendant cannot raise the statute of limitations defense in a court of law if he is identified using DNA. So, for instance, California. Let's look there. California law states the statute of limitation runs out when an arrest warrant is issued, in which that a warrant names or describes the defendant within the same degree of particularly required for a complaint. So in 2010, the California Supreme Court ruled the arrest warrant had described the defendant solely by his DNA profile and was therefore sufficient to stop the statute of limitations from running out. Take a look now at your activity on page 39. Go ahead and take a look at this activity and complete it to the best of your ability. Remember, if you have any questions, you know where to find me.